I'm really excited that you're here to join us for class tonight. This is going to be a 22-minute pre-recorded estate planning class. Tonight, we'll be talking all about estate and legacy planning and how to keep your family out of court and out of conflict. This is a serious topic and one of the most important topics you will consider. My name is Carol Lawson, and I am an estate planning and probate attorney in Clearwater, Florida. We serve families in all counties throughout the state of Florida, virtually via Zoom, and have offices in Pinellas County, Florida. Tonight, I'm going to teach you all about how you can put an estate plan in place that will actually work when your family needs it the most. I just wanted to first thank you for joining me on this presentation. If you call our office and mention this presentation, we will schedule you a free 15-minute call with me to talk about you and the people you love and how we can protect them. So for your 15-minute free consultation, call our office after the presentation and mention the presentation. The reality is that estate planning is not about you. It's about providing for the people you love. I help families create a plan that will work when your family needs it to and will keep them out of court and out of conflict. What happens to your family if you have no estate plan in place, or only a document here or there, or maybe an outdated plan that hasn't been looked at in years? What happens when you're either incapacitated or no longer around? How vulnerable is your family? Will there be problems? Which is why a personally tailored estate plan can solve all of these problems by keeping your family out of court and out of conflict. I just want to give you a little bit of background about who I am and why I practice estate planning law. I became an estate planning attorney because I have been in the exact position that you never want your family to be in while I was growing up. Estate planning resonated with me because my parents were divorced when I was 7 years old, and my father died without a signed will when I was 16 years old. I then spent my senior year of high school and the first part of college driving back and forth to Detroit, Michigan's probate court, fighting his relatives and an attorney with an alleged unsigned will who wanted to be appointed custodian of the estate funds and my inheritance. You can imagine this was an extremely frustrating way to spend my late teen years. Years later, when I went to law school, I was talking to my estate planning and tax professor, Kim Colgate, about my dad's probate estate. If my dad's so-called attorney had created a trust and my dad had transferred his assets into the trust or named the trust as the beneficiary on the assets, which would have made the plan work properly, I would have been able to avoid years of litigation. Our firm does not just put in place one-size-fits-all Word documents. We will help you fund your plans, transfer your assets into the trust, and set up any arrangements that are necessary for you. I make a commitment to never let my clients suffer what I suffered and to create you something truly meaningful in the form of an estate plan that will actually work for your family's needs and provide the best client experience while doing so. We will file your deeds for you in Pinellas County. If you bring your beneficiary forms into the office, we will help you complete them. We will draft your deeds, assignments, and help you set up ABLE accounts if necessary. Our goal is to make this easy and complete so that your family can avoid probate court. Let's discuss some sample scenarios. The first is a family of three on vacation, a mother, father, and their child. Let's call them the Horns. The Horns are visiting their best friends in northern Michigan. The family has a serious boating accident in Torch Lake. The father dies on the scene, and the unconscious mother is airlifted to McLaren Northern Michigan Hospital. The police turn the child over to Child Protective Services and contact their friends, Linda and Ed, who were listed as the couple's emergency contacts. Linda calls the husband's sister, Jennifer, and wants her to pick up the child. Jennifer asks Linda to pick up the child and care for him until Jennifer can arrive from Florida. Linda will just take custody of the child and look after him in the meantime, right? Wrong. Linda can't take the child. You see, until the legally nominated guardian comes forward, the child must remain with Child Protective Services in a strange state or with people he does not know. The police and Child Protective Services ask Linda if she's the legal guardian of the child and if she has any paperwork to prove it. Linda tries to explain that she's a lifetime friend and the child knows her and trusts her, and that the father's sister, Jennifer, is on the way from Tampa. The child confirms the family's relationship with Linda and Ed, and that they are staying in Alston with them, and that he wants to go with Linda. Sadly, the police have to inform Linda and the child that the child will need to be placed in the care of strangers until the child's legal guardians can come forward or one can be nominated by the court. If the mother was conscious, she could tell the police to turn her son over to Linda and Ed. But she can't communicate. She's in a coma. She's incapacitated in the hospital. So they will have no course of action other than to turn the child over to Child Protective Services. The parents had no will in place or any other document that nominated a legal guardian for the child. So now the sister, Jennifer, will have to be nominated by a court in Michigan to be the child's legal guardian to take him back to Florida. If you're a parent with a minor children, this would be one of the scariest scenarios you could consider. I mean, can you imagine how traumatic that would be for a small child to go through? Our child protection package includes a short-term guardian nomination document for the child and a pre-needs guardianship document for each of the parents. We would have had the couple nominate temporary guardians like Linda and Ed and the sister to be able to act as first responders and quickly arrive on the scene in emergencies, take legal custody of the kids temporarily until the parents recover or the court sets up a permanent guardian if they die. That way, your children are always with exactly who you want them to be with, no matter what. Copies are given to the temporary guardians, including electronic copies of the documents. So, Linda could have just pulled up the short-term guardian nomination document on her phone, showed it to the police, and they would have allowed her to take the child home with her. Let's say the mother lives. She never remarries. She never does any estate planning. So, when mom dies, the son calls the office And we have to explain to him that he is going to have to go to probate court because his mom died still owning all of her assets in her personal name. If you die still owning all of your assets in your personal name and you have not listed a trust as a beneficiary on the assets or a person directly, then your family has to go through the probate court process in order to legally get ownership of the assets you leave behind based on your will, which says who you want to give your assets to. Or if you do not have a will, it will be who the state law says your assets are to be given to. So let's say mom died owning her $600,000 home, a $500,000 in a 401k, which had the son named as the beneficiary, and a $100,000 money market account with no named beneficiary. All assets are still in her personal name. The now adult child will need to spend the next 9 to 18 months or longer in probate court to get ownership of the home and the money market account. So instead of being able to grieve for the loss of his mom, he will now have to deal with the probate court process. The probate court process, when you add up all the fees that are involved with probate court, from attorney's fees, personal representative fees, bond fees, publication fees, court costs, etc., can be quite expensive. The fair market value of the probate estate in this scenario is $700,000. That's $600,000 home and the $100,000 money market that did not have a beneficiary named on it. In Florida, the average probate attorney fee in a formal administration that is non-contested, set by statute, is 3% of the fair market value of the estate. So, in this case, $21,000. Assuming we are in Pinellas County, the filing fee is currently $400, and the publication fee for the court observer is currently $155. So, to even open up the case, the son is going to need $21,555. But the cost does not end there. The court is going to require a bond, and he is going to have to pay a fee for that. Also, if his mom did not appoint her son as the executor in her will, then whoever is the executor of the estate can also take a fee for the administration of the estate. Under statute, that's another 3%. So $21,000 that the son will not receive. If the son is the executor, he may also take the fee before creditors are paid in the estate. The son can also recover all of his expenditures involved in the estate prior to creditor or beneficiary distribution. So, as of right now, the $700,000 estate has paid out $42,555, plus, let's say, $500 for the bond cost, for a total of $43,055 as their one claims and expense before their claims and expenses. The estate value is now $656,000. Wait. $656,945. Since the mother was a resident of the state of Florida, she can declare homestead exemption, which means that the $600,000 home can be transferred to the son through the probate without the mother's creditors being paid, with a few exceptions such as mortgages, homeowners insurance, property taxes, and the likes. So the value of the estate is $656,945. $600 of that passes directly to the son. So that leaves claims to be made by the IRS, Agency for Healthcare Administration, EMS, and other government agencies. The next level of claims would be the creditors. Their only claims that are made are the mom's credit cards and utility bills totaling $20,000. The son, as a beneficiary, now receives $16,945 of the original $100,000 of the money market account as a beneficiary, as, as a distribution, along with the real property of his inheritance. So let's say your son receives their inheritance outright in their personal name. They can lose up to 50% of that inheritance should they have a future divorce and had commingled the funds and assets that they received from you. Also, if your child was facing a lawsuit or bankruptcy proceedings, those lawyers and banks can take anything under your child's personal name with some exceptions. Currently in Florida, the equity in your home is subject to limits based on how long you have owned the property. You must have owned the property for 1,215 days, approximately 3.3 years, to receive protection of all the equity in your home under Florida law. Otherwise, all of the as of this writing, you can be capped at $125,000 under federal exemptions or $189,050 under Florida exemptions until March 31st, 2025, if you do not qualify for full exemption. So, how can we fix this? We can fix these concerns through proper estate planning. Instead of dying without any estate planning, let's say mom came into my office after she got out of the hospital. Mom did her estate planning, reviewed it yearly with us to make sure all her assets were transferred into the trust, and amended the trust as needed. We helped her set up a revocable trust so that her son, the successor trustee, can now avoid probate. If you put your assets into a revocable trust and you have full control of the trust during your lifetime, assets you own, like your home and money market account, are taken out of your personal name and put in the name of your living trust and a real estate trust, or the trust is named as a beneficiary on your financial accounts. You have full control over the trust, and when you pass away, your successor trustee has full control. Your trust will own all of your assets when you die. They will not be owned in your personal name, and they will not be given directly to the beneficiaries. There is no need for your family to go to probate court. In our fact pattern, Mark, we helped to transfer all of his assets into his trust. So when Mark died, his home and money market accounts were owned in the name of his trust, and his 3 adult children were able to receive ownership of those assets in a matter of weeks in the privacy of my office. No 9 to 18 months of probate court, and no probate costs, just trust administrative attorney's fees. One of the biggest mistakes people make right now is to just have a will. A last will and testament does not avoid probate court. If you die with a will, you still die owning all of your assets in your personal name, which means your family still has to go through the long and expensive process in probate court. Only a trust where your assets are owned by the trust is actually going to help your family avoid probate court. Instead of having Mark's kids receive Mark's money from the trust outright in their personal name, in this scenario, we're going to have each kid receive their inheritance in the name of their own lifetime asset protection trust that they are the trustees of. So that way, the kids' inheritance are protected from any future divorce, lawsuits, or bankruptcies they may get into. A trust just makes things way easier on your loved ones after you're gone and allows them time to grieve their loss of you in peace rather than dealing with a long, expensive probate court process after you're gone. Excuse me for a second, I need to take a drink. So, let's say you got an estate plan in place that keeps your children out of court and keeps them out of conflict with each other after you're gone. Now, they're really going to want something for the rest of their lives to remember you by, and I'm not talking about your money. I'm talking about something that is your intellectual, spiritual, humor, stories, something about who you were as a human being, what is important to you. It's about what you want, about the values you want to share with your loved ones, stories, experiences, things that you want them to remember about you. Our office can help you prepare a video for their family so that they can transfer memories to their loved ones if you are interested in doing so. This is especially important if you have young children. I'm bringing this up because I'm looking back and I don't have any videos or audios of my dad. I have a few pictures. I don't have any recordings. I was 16 years old when he died. But as time goes on, it's getting harder and harder for me to remember him. For instance, I don't remember what he sounded like. I'll never truly know my dad, and it would have been nice to be able to pull up a private video or audio that he made specifically for me, just to tell me who he was and what was important to him, and just what he wanted to know about life. There's a lot of information that I've shared here with you tonight. And there's a lot of things that could happen to your family. For example, if you become incapacitated, who will look after you if you do or do not have an estate plan in place? I mean, you've seen from the story of the Horn family, you know how serious the financial and emotional consequences can be on a loved one that you are leaving behind for those of you who do not have an estate plan in place. If you have an estate plan in place, maybe get it reviewed. Some of you have old estate plannings with documents that were drafted 10 years ago, and forms change. The durable power of attorney form changed in 2008, and it changed again since then. Children grow up. They don't need guardians anymore. Beneficiaries may die. So, as you see, from my own story about my father's failure to have an estate plan, how the typical one-size-fits-all solution that most traditional estate planning firms or the do-it-yourself online software provides is just going to leave your family at risk. Now, if anything I've said tonight has started you thinking about what will happen to the people you love, what will happen to all of your assets when I die, if and when something happens to me, what will they do? Would my family end up in court? Would my assets potentially be lost? Would my children's inheritance be at risk of being taken away if they ever got divorced? I want you to get a way to answer those questions. And to do so, I'm giving you a personally tailored 15-minute one-on-one discovery call with me. This is a free 15-minute discovery call where you and I and your spouse, if you're married, can hop on the phone and discuss your assets, your planning goals, and determine how I can help you achieve the desired effects you need to secure your family. Having your spouse on the line is important because I'm going to be representing both of you. I need to make sure that we are all on the same page. You can book your free 15-minute call with me at 727-410-2705. I do not want to get into pricing because pricing is important, but a comprehensive estate plan can cost anywhere from $1,500 to $10,000 depending on your family's needs. You might need LLCs or sub-S corporation, multiple real estate trusts, a special needs trust, a Medicaid trust, in addition to your revocable trust. So, since every family has different needs and different estate planning goals to accomplish, you might need a will and a ladybird deed, or some of you will need only wills and powers. Some of you will need a will and only a revocable trust. Some of you will need wills, powers of attorney, revocable trust, real estate trust, or any combination of the above. So, I can't tell you exactly what your family's estate plan is going to cost here on this webinar because I just don't know exactly what you're looking to accomplish. So, that being said, when you call and schedule your free 15-minute discovery call with me, I'll be able to ask you a few questions about your assets and what you're looking to accomplish. Then we'll be able to narrow down the range of what you could expect to pay before we take any further steps. Your discovery call with me is complimentary. It's simply an opportunity for us to speak with you about your goals and your needs and explain our process of how we accomplish those goals and give you clarity on what you can expect. I only open 8 spots for the discovery calls with me each week. So if you are interested in taking advantage of this opportunity and finally getting the necessary answers that you need to put the right estate plan in place to protect your family, then you should schedule your free 15-minute discovery call now. I know some of you are probably have questions based on what we discussed here tonight. So call us at 727-410-2705 to schedule your complimentary call. Thank you for joining me tonight and staying to the end of the video.